Welcome everyone. This is the 6th session of the IBIS Prep crash course for the MBE. And today we're going to do everyone's favorite subject, civil procedure. And I have with us an expert, Matt Beckerman, who scored really high on the MBE and is going to help us navigate civil procedure. And when I said everyone's favorite subject, I hope everyone knows that I wasn't being completely serious, because some people really don't like civil procedure. Oh, perfect timing. We had a student enter the room. Good timing. So I guess that, can you see my presentation? Anyone? Or it says loading?
It says loading.
You can see a blue screen?
I see a black screen.
Oh no, okay. That's just usually what happens with Zoom, but no worries. I bet now you can all see my screen, right? Blue screen, IBIS Prep logo in the corner, a bird? Yes?
Yeah.
All right, cool. All right. Morning lesson plan, football game predictions. We got a few of them. Anyone have any other predictions officially on recording? Nothing? All right. We did a 20-question quiz. We had one student get 95%. That was pretty awesome. Man, no one has a football game prediction. For the record, I got Eagles by 24 points. It's going to be a good game. This is me. This right here is Boca Chica, Key West. It's a pretty sweet location. You guys should mentally be somewhere after the test. That's going to be fun and relaxing. You already know about my business. We did enough messing around today. Mindfulness, this person has a tree inside of his head. That's very mindful. Daily affirmations. I'm going to focus on passing this test. I'm going to focus on passing this test. I'm going to focus on passing this test. That's something that we could all say to ourselves, and it means more than it means to other people, because to focus on passing the bar exam requires a lot of outside distractions. Let's just focus together on this exam. Study strategy, 3 weeks until test day, more or less, maybe 3 days and some change, but I have this course, civil procedure, next week, criminal procedure and crim law, and then finally a review session that's going to be moved 2 hours earlier for the Super Bowl. So we really got to lock in, black out all distractions, suffer now to live your life as a champion, Muhammad Ali. Consistency and regimentation are keys. Focus on memorizing the cram guides, which we'll go over today. Like always, consistency and regimentation, same thing every time. Take full-length practice tests weekly. I think you should be doing that every week. Take like a full-length practice test, 200 questions every week. I would highly recommend that. 25 to 50 questions per day, 2,000, 3,000 total. And now strive for 70% in all subjects in the month of February. February officially starts on Wednesday? Tuesday? Wednesday. Starting Wednesday, that's when I'm really measuring people's performances. I mean, measuring is a relative word. Just do your best. After all else, I've seen people pass this test who've been getting like 58% on test day. I've seen people fail this test who are getting 80% on test day. You know, it is all relative and individualized, but generally speaking, one size fits all. Strive to push for above 70% on all subjects for the month of February. That'd be great. Civ Pro Stats. Of course, Civ Pro is like the most diverse. Civ Pro is the hardest subject. Another student's entering the chat class. Civ Pro is the hardest subject. We can't deny that. And it's statistically true. It's also the newest subject, so there's the least amount of thought that goes into preparing students over the years. But hopefully we will add a lot today. So what's tested? Jurisdiction and venue, pretrial procedures, motions, law applied by federal courts, jury trials, verdicts and judgments, appealability and review. Total scored questions for Civ Pro, 25. It's all across the board, right? I want today to be interactive. I know it's kind of counterintuitive because Civ Pro is so boring and so drone. I tried to get pictures to put up here. There's no pictures for civil procedure. It's a lot of discussion. So if you know something juicy or interesting or tasty, drop it. Matt, I'm asking you, anyone, not just Matt, everyone in the audience, feel free to make this a discussion and we're just adding to the knowledge bank of civil procedure. Civ Pro Approach, I borrowed a lot of this material from my past instructors, so don't kill the messenger, but identify the parties and what they're seeking to accomplish and how they're seeking to accomplish it. Like, defendants, plaintiffs, are they bringing a motion? Are they trying to get out of the case? Are they trying to get more money from the case? Like, what's going on and where are they? Determine there's PJ, SMJ, and venue. We'll talk about those. Determine the stage of litigation. And we'll go over this about, there's certain pleadings that come at the beginning, that come at the middle, that come at the end, and just kind of orient yourself about where in this civil litigation are we. Always eliminate wrong answers. That can't hurt. And then remember some important things. Only defendants can remove. I feel like people get that question a lot. ERIE doctrine. Can anyone start off the interactiveness by telling me, Matt, you don't have to be the first volunteer. You're kind of like the savior, the rescue boat. Does anyone know what the ERIE doctrine is?
Yeah.
I can take a stab at it. Oh, go ahead, Grace.
No, go ahead.
I think it's like when there's a federal rule and a state law that are both, I guess, on point or clashing. You have the federal rules for procedural matters and the state rules for substantive matters in the case.
Excellent. That's good start to it, and we'll go deeper in that. And then Mark, are you here?
Yes, sir.
I did just want to ask you briefly, what do you think about issue preclusion and claim preclusion? Just, briefly, what does that mean to you?
Issue preclusion is like you're barred from bringing up an issue that was already decided on. And claim preclusion, you're barred from bringing up the whole claim, basically in simple terms.
That was pretty simple as it gets. Does anyone have any other thoughts about issue preclusion and claim preclusion?
I think like issue preclusion was like fully litigated.
Mm-hmm.
And then I'm drawing blank on the claim.
Issue preclusion, collateral estoppel versus claim preclusion, res judicata. And then one of them is between the same parties, right?
I think
that's a claim preclusion, right?
Exactly. The claim preclusion, it must be the same configuration of parties, the same plaintiff as the plaintiff and same defendant as the defendant.
Right. Claim preclusion is more in touch with the parties. We'll go over this stuff. Trust me, we'll go over ERIE and claim preclusion, issue preclusion. Matt, at any point if my internet goes down, just teach for a little bit because it's been a tough morning. So I'm counting on you. Sorry to say that. All right, let's start with PJ. Personal jurisdiction. I want to keep it simple. Silly. Does everyone understand? Is there anyone in the room who doesn't understand personal jurisdiction? Is this easy to everyone? You get these questions wrong? All right, so I'll just fly through PJ, right? It can be in person through consent, service within the state, or domiciled. And can someone enlighten me where's domicile if you're an individual?
Where you reside.
Right, where you reside and intend to stay. So
yeah, you need a subjective intent to stay there.
Yes, sir.
If you go to like Tulane for college and you're from Massachusetts, but like you never intend to like live in Louisiana long term, and you're still going to be a Massachusetts resident even in your senior year. 100%.
Corporations are domiciled where they're incorporated and have their nerve center, which is their headquarters. So it's not where they have business operations, it's where they have their headquarters. And then most states have long arm statutes that allow personal jurisdiction via minimum contacts. Can someone tell me what's necessary for minimum contacts? Fairness, relatedness. What else?
Contact.
Yeah, and then contacts, sufficient contacts in the state. In rem jurisdictions over the property, always look for where the property is located unless it's not about the property itself. Maybe if it's about a fraud action, then look where the contract was, but like 95% look for where the property is. And then quasi in rem, a legal action based on property rights of a person absent from the jurisdiction. I won't stress about quasi in rem. There's a lot to stress about with civil procedure. I'm just kind of going over the basics at first in this presentation, but feel free to jump in at any time. This I just took from my past instructor. Subject matter jurisdiction, a court's competence to hear a certain type of case. When you think of SMJ, we'll go into these 4 vehicles: federal jurisdiction, diversity, supplemental, known as tagalog, and removal jurisdiction, which is the defendant's method. Cool with that? Federal, diversity, supplemental, removal. Let's kind of take a peek. Federal courts have the power to hear claims arising under the federal constitution. Well-pleaded complaint rule. Plaintiff's claim must be based on federal law. It does not matter that the defendant's defense is, right? To get into federal court, it's what's on the complaint. That's why the courts say we look at the face of the complaint. The district courts have the original jurisdiction of all civil actions arriving under the Constitution, laws, and treaties of the United States. Any other points about federal jurisdiction anyone wants to enlighten us with? Let's talk before we get into diversity, anything about federal jurisdiction that you've seen on questions or anything? Any tricky things? Just remember.
Yeah, also be like the treaty and things of that nature. Like admiralty and maritime and IP.
Exactly. That's some other ones. Yeah. Maritime, IP, bankruptcy, between foreign nations. I think we're getting a little into common law too, but yeah, we look at the federal jurisdiction as a way of getting to federal court. So diversity is founded on assurance to non-resident litigants of courts free from susceptibility to potential local bias. Okay, that was one of my previous instructors. But what do we need for diversity? These 2 elements, right? Over $75,000, and we need complete diversity of the parties. Every defendant and every plaintiff is from a different state, right? Is domiciled in a different state. There's some exceptions right here for minimal diversity: Federal Interpleader Act, class actions of more than 5 million, interstate mass torts, when you only need minimal diversity, so just one plaintiff and one defendant to be different. I don't really see that many questions on minimal diversity. Just make sure, you understand diversity is a huge piece. And as we'll see later in the slides, subject matter jurisdiction is something that can be brought up at any time. So if for any reason there's no diversity, that's an important thing to be on the lookout for. Any thoughts about diversity? Anyone wants to add?
Yeah, if you have a supplemental jurisdiction question, make sure you know, like, is it supplementing federal question or diversity jurisdiction? Because adding another party will destroy diversity. It doesn't matter because the case is a federal question case.
We're about to do supplemental jurisdiction, so it's good though. But diversity, solid. $75,000. Every plaintiff, every defendant are estados diferentes. Here's a diversity example. I had to change the names. That's all I did. To figure out complete diversity, write out the question with verses. Both sides of the verses need to be completely different. Okay. Hypo. Jalen and AJ, Devontae versus Christian. Is there complete diversity? Is there minimal diversity? Well, yeah. Every defendant, every plaintiff are from different places. That's cool. Now, Jalen, AJ, and Brock. No. Jalen and AJ versus Brock and Christian. Is there complete diversity or minimal diversity? Well, there's definitely not complete diversity because AJ and Brock have come from the same state. Does anyone really understand minimal diversity? Like it applies in these situations? I mean, there could potentially be minimal diversity if like this is a class action and the representative was Jalen, and potentially. But remember, corporations have numerous states of citizenship. Write them all down. They're domiciled where they're incorporated and where their nerve centers are. Here we go. This is your time to shine, Matt. Supplemental jurisdiction. Diversity in federal question gets you into federal court. Supplemental jurisdiction may permit an additional claim that does not meet the original jurisdiction requirements. It only works if the case is already in federal court. So we're going to use the common nucleus test. The claim must share a common nucleus of operative fact with the claim that invoked diversity or federal question. The common nucleus of operative fact is met by claims that arise out of the same transaction or occurrence. Federal question. The court may hear a related state claim by any party, and diversity. this is what Matt was getting at, I believe. It permits the defendants to adjudicate related counterclaims, cross-claims, and impleaders. So the note is no diversity is needed with parties that the defendant brings in. And Matt, can you elaborate on what this all means?
Yeah, so when the defendant brings in parties, as far as I understand it, in a diversity case, like if the defendant like impledes someone or interpleads or cross claims or whatever, even if that would destroy diversity, if the plaintiff brought them in, it's fine, because I think the defendant probably gets more leeway there because they didn't really have a choice. They're the ones being sued.
Exactly.
But if the plaintiffs bring someone in that would destroy diversity, they wouldn't be allowed to bring the
I like the rationale there. Like, you brought me into this federal court mess and I'm trying to bring someone in, and now you're going to say, oh, you can't bring him in because it destroys diversity. It's kind of like, it doesn't make sense. And that's a good way of looking at civil procedures. Actually frame yourself in, on the chessboard, looking on top of it and be like, does it make sense to restrict them in that means? And if the defendant is bringing them in out of the same common nucleus of operative fact and it would destroy diversity, then it's okay. And the court may exercise supplemental jurisdiction, right?
Yeah.
They may.
Also,
go ahead.
Yes. Oh, I think you're about to say it, but yeah, it's discretionary.
Yeah, discretionary. They may exercise. They definitely will get you on questions like this. Removal. Only defendants can remove. I can't tell you how many times I get questions in the past. I've gotten a question wrong because I reading too fast and forgot. Only defendants can remove. So I put in red. Very American presentation today. So removal moves a case from state to federal court. A transfer is between federal courts. Don't get the two concepts confused. On the MBE, if discussing a case being in one district versus another district, think transfer. Usually questions dealing with which law applies, the one from first venue where filed if proper, or law of second venue versus not proper. So the difference between transfer and removal. Removal is state to federal. Transfer is between federal courts. Only defendants can remove. And again, we're explaining things deeply in this session. Why does that make sense? Because the plaintiff chose the forum in the first place. So why would they get to change their minds after filing in state court, right? Like, you can't remove as a plaintiff. You should have figured that out before you filed. The defendant is the one it's now my move to move my chess piece. Removal is only proper if cases could have been brought in federal court anyway. Sneaky way to test subject matter jurisdiction. It makes you engage in a subject matter jurisdiction hypo by asking, is there federal question and is there diversity? So removal is only proper, like you can't, if it's going to destroy diversity, removal is not proper. Supplemental jurisdiction, potentially, if brought by the defendant, if it destroys diversity, that's kind of like a good way of thinking about it. Any thoughts here about removal, Matt?
Yeah, defendants can't remove on the basis of diversity jurisdiction if they're in their home state court.
Right, a forum state defendant, exactly.
Right, forum state defendant rule.
Right, exactly. Perfect. Removal, part 2. Federal has the same rule, diversity, same rule, complete diversity, $75,000, but we can't remove from state court if the defendant is a resident of the state.
Okay, you have it.
That's exactly what you said, yeah. All defendants must consent to removal. Don't be tricked. Well-pleaded complaint rule still applies. Just because defendant is raising federal defense does not mean it gets to be removed. Federal issue must arise from plaintiff. People forget that when it comes to removal. So just because the defendant is raising a federal defense does not mean it gets removed. It has to be on the face of the complaint, right? How does one remove? One would ask. File for removal in federal court. State court is notified. If improper, the plaintiff can contest it, and that federal court, not the state court, can remand it back to state court. But removal is a big deal. You can tell these slides aren't necessarily my language, but I like them. They're very well written. Civ Pro is not especially my bag, but we're jamming in it today. Any questions so far about these concepts? There's always stipulations, exceptions. Go ahead.
Sorry for the loud kid. Can you go back to when you said that the defendant can't remove if he's in his home state?
Yeah, can you explain that more, Matt?
Sorry, I didn't hear the question.
About the forum state defendant rule, could you explain that to Sam?
Oh, so like the idea of diversity jurisdiction is that federal courts are more impartial and state courts might be biased toward like their own residents. So if a defendant is trying to remove on the basis of diversity jurisdiction in their own state, it's just not allowed because it's thinking like they're already in their home state, like they have the advantage, like there's no reason for them to remove. At least that's how I understand it.
Right. So a forum state defendant you can't remove in your own state. You can only remove to
Yeah. So if like a Kansas resident is suing a Nebraska resident for $1 billion for I don't know something, and they're being sued in Nebraska state court, the Nebraska defendant can't remove to diversity jurisdiction to federal court on the basis of diversity.
Right, solely on the basis of diversity. They could if there was a federal question, and they could remove to a different state federal court, but not in their own, because what's the difference he's saying in defending in your forum court?
What Matt said, that's the whole point of removal. It's because the defendant needs to be like protected by the state. He's the one being sued at, so
exactly, I like that. He's being protected.
That's the whole reasoning. It's good to know it for the question. Like,
perfect. What about venue? I just kind of brought this in. It wasn't even, no one really talks about venue. I just got this from the statutes. A civil action may be brought in a judicial district in which any defendant resides, if all defendants are residents of the state in which the district is located, a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of the property that is the subject of the action is situated, or there's no district in which an action may otherwise be brought as provided in this section, and then as provided in the section. I didn't copy and paste the rest of it, but basically where
there's personal jurisdiction over a defendant.
Yeah, where they have personal jurisdiction over the defendant. Thank you, man. So basically, where any of the defendants reside or where the cause of action accrued. There's other thoughts about venue that I didn't really talk about that we'll see this afternoon, like forum non-convenes and like transfer venue. You have any thoughts about venue you want to add, Matt?
Yeah, if it's like, if they ever talk about like foreign parties or like it occurring in a different country, it's almost always going to be brought under 3.
Yes, exactly.
I've definitely seen like a bunch of questions where like it takes place in a different country, and like it can't. That's not in the U.S., so it can't be brought under 2. And if the defendant's foreign, it can't be brought under 1.
Can you remind the class what I'm missing right here? So I'm going to add it in. But
right. If there's no district in which an action may otherwise be brought as provided in this section, any judicial district in which as far as I understand, like there's personal jurisdiction over a defendant.
Right, in which is perfectly. So that's the third prong, but usually it's where they reside or where the cause of action accrued, and in the absence of all of them, where the court would have personal jurisdiction over the parties. And then forum non-convenes is like in the interest of, there's all the witnesses are here. This is where it would be most convenient. We could potentially transfer there. Service of notice, file summons and complaint, and copy of complaint against a defendant. Hey, buddy, you got served. Federal and state rules prefer personal service, but they do allow for substitute service. So serve on another person if they do so by leaving at defendant's dwelling or usual place of abode with a person of suitable age, right? States have specific ages, and federal it's just a suitable age. Process can also be served on an agent of a company or business. You cannot serve someone in a state if she's only in the state as part of judicial proceedings. But if you're voluntarily in the state, you got served, buddy. And written waiver is valid if mailed to defendant by first-class mail. Postage is prepaid, and the defendant returns within 30 days. Any thoughts about service of notice? Everyone knows what that means, just letting the person know that there's litigation. ERIE doctrine, we talked
about. There are a bunch of rules. There are a bunch of like tiny random rules about serving. So definitely read Federal Rule 4 because that's like all about it.
Is there any one rule you could think of that's interesting? I don't mean to put you on the spot. I mean,
like, interesting is kind of a loaded term here, but
is there any rule you could think of?
I don't know if any of them is really interesting, but I think there's sometimes questions where like they try to you have to deliver it to an adult, so someone 18 or over who lives at that domicile. So you can't deliver it to a housekeeper or a gardener or whatever. I think there's sometimes questions about that.
Yeah. But I was thinking about that because yesterday I did a question about what Matt is saying, and it specifically said that the federal rules doesn't require that the person living is a family member, therefore a caretaker is okay for federal rules.
Yeah, but probably
And-
not a gardener, but the caretaker probably.
Yeah, the person that, you know, like the housekeeper, someone that lives there, you know, the person that answers the door.
Yes.
All right, cool. Well, let's not get lost in the weeds. Let's continue through civil procedure. ERIE doctrine. The ERIE doctrine is a fundamental legal doctrine of civil procedure in the United States, which mandates that a federal court called upon to resolve a duty not directly implicating a federal question must apply state substantive law and federal procedural law. So this was explained by May at the beginning of class, that ERIE doctrine comes up. Just look to see, are they going to apply the state law or the federal law? And they're going to apply the state law in which the federal court is sitting, right? So if they're sitting in Pennsylvania, they're going to apply that state substantive law. Some things that I looked up, I mean, not looked up, but I remember, is if it's a statute of limitation question, it's going to be substantive. If it's about relation back, that's going to be procedural, which will be federal. If it's damages, it'll be procedural, which is federal. And if it's privileges, it'll be substantive, which is state law. Grace, I'm right with these two? All right, yeah, I checked it with Grace before class on these bottom two. Those are just kind of specifics from questions. These come up, and make sure you understand ERIE doctrine. Someone in the chat said something. State law conflicts with federal. Yeah, federal rule always wins, right? Preemption. Federal law will preempt state law. And another thing, oh no, that's con law, that there's, you know.
It's like the Supreme Court has held that like the federal rules of civil procedure just like always like hold out.
Yeah, so let's talk about the life cycle of civil litigation. Sounds fun, right? So civil litigation can be divided into several stages, including investigation, pleadings, discovery, pretrial proceedings, potential settlement or trial, and even appeal. Discovery is typically the longest and most labor-intensive stage of a case. I don't get too in detail in some of these stages here. I don't get too in detail into discovery or pretrial proceedings, but I do talk about these motions because it helps people frame a case, and I'll get into the specifics on the next slide. But consider the similarities between a motion for judgment on the pleadings, summary judgment, motion for judgment as a matter of law, renewed motion for judgment as a matter of law, motion for a new trial, and motion for appeal. That's kind of how they're all kind of saying the same thing. Like, this is BS. We want to end this. It's just, when do you file them? So in particular, a judgment on the pleadings is granted in the rare instance where a party is entitled to a judgment as a matter of law based solely on review of the complaint and the answers, right? You look at the pleadings, you're like, come on, judgment on the pleadings. You could also probably file a motion to dismiss for failure to state a claim for which relief could be granted, right? There's like a different avenue there, but judgment on the pleadings is just like early, right away, like this is trash. Summary judgment is appropriate. The movement shows there's no genuine issues as to any material fact, and the moving party is entitled to judgment as a matter of law. Lead, are you with us right now?
Yeah, I am.
Okay, how are we going to look at the facts? Most favorable in which light?
So the light of the non-moving party.
Yes, exactly. We're going to consider the facts in the light most favorable to the non-moving party. And if so, if there's no genuine dispute of material facts, then summary judgment is appropriate. More or less the same thing for judgment as a matter of law. Sorry, I live in the hood. No, I'm just kidding. A motion for judgment as a matter of law is a motion made by a party during trial claiming the opposing party has insufficient evidence to reasonably support its case. So again, JMOL, it's like similar to summary judgment, but summary judgment is coming after discovery, right? JMOL is coming during trial. And then renewed judgment as a matter of law is a party's second chance as judgment as a matter of law. Renewed JMOL is decided after a jury has returned its verdict and a motion to have that verdict altered. Does anyone know what JMOL used to be called back in the day?
Directed verdict.
Directed verdict, yeah. I have to stop you, Matt. You're like Ken Jennings on the buzzer. The grounds for granting a motion for a new trial include significant error of law, verdict going against the weight of evidence, irregularity in court proceeding, jury misconduct, newly discovered material evidence, and improper damages. Moving right along. 12B defenses. This is an important slide. So we all know these.
It has to be newly discovered evidence that could not have been reasonably discovered. So
Right.
if you find new evidence just because you were lazy before and like didn't like look through everything, like that's kind of your fault, and they don't let you.
100%. Classic question is, oh, you found it in your desk later, like too late. It has to be like that you couldn't have reasonably discovered before. All right. 12B defenses. This is important, right? This is like someone files a complaint against you, and you know, either in your pre-answer or your answer, you're gonna be like, either in a pre-answer motion or an answer, you're gonna say it's trash. And if you're gonna raise personal jurisdiction, venue, insufficiency of process, a problem with the summons or complaint, or insufficient service of process, you better bring it up the first time it becomes available. Usually that's right off the complaint. There is this question where it's like, oh, then they amended the complaint and now venue became an issue. Well, now you could bring up venue even if you had a motion before, because it's the first time that venue became waivable. But at the beginning, just think of it simpler terms. When they file a complaint against you, you want to file back either a pre-answer motion or an answer that has 2, 3, 4, or 5, or you're going to forever lose it. And there'll definitely be questions where it's like you filed a pre-answer asking for more information or something, and then you filed an answer saying lack of personal jurisdiction. Well, it's too late, right? Subject matter jurisdiction can come at any time. Same with 6 and 7. Failure to state a claim upon which relief can be granted. And that could be like statute of limitations. And then failure to join an indispensable party. That could be like a necessary party, someone that it wouldn't be possible to grant judgment adequately without their involvement in the case. Yeah, that's what I'm talking about. SMJ is never waived and can be raised for the first time after trial or even on appeal. Anything about 12B6? 12Bs?
Yeah, you get basically 2 tries for most of them, like either in your first affirmative response, or you can like move for it on your own.
Yeah, exactly. You get 2 tries for it, but once you do it, you lose it. All right, issue and claim preclusion. And Mark, you did an amazing job explaining this basically. I told you I was gonna put you on the spot. If anyone can help me with this, I feel like these issues are very difficult on the MBE, but they do come up. Issue preclusion, also known as collateral estoppel, is a common law doctrine that prevents a party to a lawsuit from relitigating an issue once it's been decided in a previous case. The issues in issue preclusion, but the elements of issue preclusion are whether the issues presented in the subsequent case are substantially the same as those involved in the first case, whether controlling facts or legal principles have significantly changed since the first case, and whether other special circumstances were an exception to the normal rules of preclusion. So issue preclusion would be on that specific issue of like negligence, whether Tommy was negligent or not. It wouldn't be on the claim of Tommy's negligence versus Brandon's negligence. It would just be on that small issue of negligence of potentially a broader claim. Issue preclusion is more narrow than claim preclusion, right? Anyone have any thoughts about collateral estoppel?
So there's offensive non-mutual issue preclusion and defensive non-mutual issue preclusion.
Can you please explain this to us? Because
I was gonna like expand on that. So even when it says defensive or offensive, you can only ever use it against one of the parties in the first suit. So like when you say like non-mutual, like there has to have been a first suit with 2 parties, and then in the next suit, there's a new party that was not involved in the first litigation. So if there was like a car crash and between like car 1 and car 2, car 1 was found negligent, and then that person sues. This is getting confusing, but like if a person is found negligent in a first case and then he sues another person, that person can say, hey, in this first case, you were actually found negligent.
Okay.
I don't know how helpful that was. It's very confusing to explain without like visual.
Yeah, I'm gonna be honest. On behalf of everyone, I'm now more confused. But can we slow it down?
You need like a visual chart, honestly, to understand
it. Down. What does it mean to be offensive versus defensive?
So offensive is when the plaintiff is bringing it against the defendant, or it's being brought by the defendant in a counterclaim.
And then defensive
is when it's like being raised as a defense.
All right. So offensive versus defensive is the plaintiff is bringing it versus the defendant is bringing it. That makes perfect sense. And then what does mutual versus non-mutual mean?
Mutual means like it's between the same two parties.
Mm-hmm.
Non-mutual means one of the parties, well, the party not bringing it was not a party to the first suit. You can only ever bring it against someone who was a party to the first suit.
That's a lot more helpful. And they'll tell you in the question whether this jurisdiction permits non-mutual or mutual offensive or defensive claim preclusion.
And not every jurisdiction allows it.
Right, and then knowing whether they permit it or not and knowing what that means is very helpful. Offensive is the plaintiff, defensive is the defendant, and then mutual versus non-mutual refers to whether they were a party or not to the action. And it's important that issue preclusion, they don't necessarily need to be a party to the action, in contrast to claim preclusion, also known as res judicata, which prohibits lawsuits involving the same cause of action and the same parties if the court has entered a final judgment on the merits. There must have been a final judgment on the merits. The decision was rendered by a court of competent jurisdiction. The prior action must have involved the same parties or their privies, and the prior action must involve the same claim. So claim preclusion is a lot broader than issue preclusion. It has to be the same parties, same claim, where issue preclusion is more about the same issue. And Mark, is there anything you want to add to these concepts? Because you get these questions right.
Mark or Matt?
No, Mark.
No, I think you guys got it. I mean, I don't know, man.
Yeah, no, it's one of those questions where it's like, if you understand it, you understand it. If you don't, you don't. But I think, does anyone have any questions in the audience about issue and claim preclusion?
Oh, I just have another 2 comments. For claim preclusion, as you say here, it has to be the same parties or parties in privity. So if the first case is between 2 companies and then the plaintiff company is bought out by a third company, that third company is then claim precluded because it's considered to be in privity with the first company.
Nice. Solid.
And then with offensive non-mutual issue preclusion, you have to have like a valid reason for not having participated in the first suit, the party that wasn't in the first suit. It can't just like they waited around. It had to be like they were like having health issues, or they didn't know about the suit, or they had like financial problems. Like they can't just have been like aware of it and like just waiting to sue until they saw the first case.
I'm so happy I brought you here today. Those are 2 gold nuggets right there, that you can't just bring it because you were lazy in the first suit. And then the earlier thing that you said was, what was the first part again?
About issue preclusion or about claim preclusion?
Just the first comment you made. I'm sorry.
Oh, that like, if like the first party is like your direct employee or a company that you bought out, or like a company that merged in to create you, then you're in privity.
Yeah, solid concept. All right, and I think this is pretty much one of the last slides I have. I mean, there's a lot of things we could talk about. We'll look at the cram details, but class actions come up, the initial requirements. They say the acronym CANT, C-A-N-T, commonality, adequacy, representation, numerosity, and typicality. Numerosity is so numerous that joinder of all members are impractical. Commonality, at least one question of law or fact are common to the class. Typicality, representative claims defense are typical. So, look for like, you have $75,000 of damages, everyone else has $12 of damages. It's not going to be typical. Adequacy of representation will fairly and adequately represent the class. In order to determine diversity for a class action, only look for the domicile of the representative of the class, not all the members. They could try to trick you on that. Some things I think, oh yeah, more stuff. Never mind. There's maybe 1 or 2 more slides. Standards of review. Yuck, right? These are questions that you just kind of have to memorize. They're different standards that even to this day I struggle with. Abuse of discretion, clearly erroneous, substantial evidence, de novo, and harmless error. It's going to be good for everyone to just hear me read this. Abuse of discretion, where a lower court has made a discretionary ruling, such as whether to allow a party claiming a hardship to file a brief after the deadline, or many evidentiary rulings. That decision will be reviewed for abuse of discretion. It will not be reversed unless the decision is in plain error. So plain error is going to come with abuse of discretion, and it's going to be for evidentiary rulings. Clearly erroneous. Under the clearly erroneous standard, where a trial court makes a finding of fact, such as in a bench trial, that finding will not be disturbed unless the reviewing court is left with a definite and firm conviction that a mistake has been committed by that court. Substantial evidence. A finding of fact from a jury is upheld on appeal unless it is unsupported by substantial evidence. So clearly erroneous is for a trial court finding a fact. Abuse of discretion is for evidentiary matters. Substantial evidence is for finding a fact from a jury, right? Substantial evidence for the jury, clearly erroneous from the trial court. De novo, under de novo review, the appellate court acts as if it were considering the question for the first time, affording no deference to decisions below, and is applied to legal decisions of a lower court of questions of law. So the appellate court acts as if we're considering law for the first time, and it's applied to legal decisions of a lower court or on new questions of law. That's de novo review. And then harmless error is a ruling by a trial judge that, although mistaken, does not meet the burden for a losing party to reverse the original decision of the trier of fact on appeal or to warrant a new trial. This often applies to challenges to evidentiary rulings. So if it's a harmless error, then there's not going to be any reason for an appeal. If it's an abuse of discretion, then it'll be reviewed and it will not be reversed unless it's plain error. So I know those standards are tough, but I know those standards are tough, but they're helpful. There was anything else that we can think of from civil procedure that comes up? Oh yeah, I wanted to explain the difference and ask the class before I go into the cram guide review. Actually, before we take a break, does anyone know the difference between impleader, interpleader, and intervention? Impleader, interpleader, and intervention.
I know it.
Wait, let's go, Claudia. Let's hear it.
Yeah, I said it yesterday. The intervention is a non-party that can intervene into the claim. The impleader is the defendant bringing in a party that is liable, like condemnation or something to him. Mm-hmm. And interpleader, is when the plaintiff is it? There we go. I just lost it now.
Interpleader is when you're going to force two defendants to litigate amongst themselves to figure out who's responsible for the settlement or the amount. Interpleader. So intervention is when someone jumps into the case. Impleader is when we bring someone into the case. And interpleader is when we force two defendants to figure out who owes me the money. Anything else before we take a 10-minute break anyone can think about? Civil procedure? Go ahead.
So intervention is basically like the reverse of joinder. Joinder is like you're bringing in parties. Intervention is the parties are bringing themselves in.
Yes, and that
means like the rules are basically like the same. Like there's required intervention and like permissive intervention, permissive joinder, required joinder.
Right.
Wait, the interpleader was like bringing in like all the defendants against that one plaintiff, essentially.
Right. We're gonna force them to interplead among each other. That also made me think of another question. Does everyone understand the difference between cross claims and counterclaims and permissive counterclaims versus compulsory counterclaims? Just one person want to explain that? Cross claims versus counterclaims. What's the difference?
Cross claim is against cross claims is when the defendants are making a motion against each other. And counterclaim is when it's against a plaintiff and a co-defendant or a defendant. One is on the same side of one side, and then one is against each other.
Yes, cross claims are against co-parties. Counterclaims are against opposing parties. And when is a counterclaim compulsory?
When it's the same transaction or occurrence.
Exactly, which is kind of similar standard to when we're thinking about supplemental jurisdiction. If there's a common nucleus of operative fact, we'll see that word come out again if it's same transaction or occurrence. There's a lot of dates. We'll go over dates in the outlines. Any other subjects anyone just wants to touch upon before we take a break from civil procedure?
Yeah, permissive counterclaims have to independently stand. It has to meet, diversity jurisdiction or federal question jurisdiction, and then compulsory counterclaims are usually supplemental, and they have to be brought because of claim preclusion. Because it's the same transaction or occurrence, right, that can bring it in a later trial because it would be claim preclusion.
That's a good way of thinking about it. Anything else anyone wants to add? Any golden nuggets before we take a break?